All right. Again, it's 8:20 p.m. and we've been advised the jury has reached a verdict, and we'll be having the jury come in shortly. Now, I would ask that, I know there's a lot of emotion in this case on both sides, and since March 22nd of 2018 until now, if there's anybody here that does not believe that they can keep still and hold their emotions in check, now is the time to leave the courtroom. I'm going to ask that anybody in here not show any emotion and there do not be any outbursts. All right? Understood? All right. Are we ready for the jury?
Yes, Your Honor.
All right, let's bring the jury in. All right, you may be seated. Excuse me. All right, members of the jury, have you reached a verdict?
Yes, Your Honor.
All right, and would you please give the verdict and the instructions to the bailiff? All right. Mr. McCandless, please rise. We, the jury, find the defendant, Ezra J. McCandless, guilty of first-degree intentional homicide as charged in the information. And the answer to the special verdict question is yes, use a dangerous weapon. And you may be seated. All right, ladies and gentlemen, is this your verdict? All right. I'm going to do what's called polling the jury, and I'm going to ask each of you if this is your verdict. And I'm going to ask you by your juror number. All right, I'm going to list off your juror number, and I'd ask that you simply answer yes or no. Okay, juror number 30. Is this your verdict?
Yes.
Juror number 20, is this your verdict?
Yes.
Juror number 67, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 36, is this your verdict?
Yes.
Juror number 56, is this your verdict?
Yes.
Juror number 73, is this your verdict?
Yes.
Juror number 90, is this your verdict?
Yes.
Juror number 133, is this your verdict?
Yes.
Juror number 135, is this your verdict?
Yes.
Juror number 98, is this your verdict?
Yes.
And juror number 64, is this your verdict?
Yes.
All right. Ladies and gentlemen, I don't think there's enough gratitude I can express to you for your service in this matter, in the sense that you've devoted 3 weeks of your time and limitations on your liberty and so forth. And we do have a standard closing instruction, which I have momentarily misplaced. As you can see, we use a number of pattern instructions, and occasionally we stray off of that a little bit, improvise, but in any event, now that your service in this case is completed, some of you may have questions about the confidentiality of the proceedings. You are free to discuss the case with any person you choose. However, you do not have to discuss the case with anyone or answer any questions about it from anyone other than the court. If you do decide to discuss the case with anyone, including the media, keep in mind that your fellow jurors fully and freely stated their opinions and may not want their opinions made public. Please respect the privacy of the views of your fellow jurors. If any of you have questions for the court before leaving today, please let the bailiff know before you leave the jury room. And if you do wish to remain, and I will answer any questions you may have. Again, there are limitations on what the court can and cannot do or say. But we do have some information for you. In a case such as this, often the things that you see or hear throughout the course of the trial can have, I think it was brought up during the trial, secondary trauma. If we have some information for resources, if any of you feel that you're struggling in any way with any of the things that you've seen or heard about or had to deal with in connection with this case. So we'll provide that to you before you leave tonight. And again, if you have any other questions for us, we can help you with that. But members of the jury, on behalf of Dunn County, the court would like to express its sincerest gratitude and appreciation for your service in this case. The court recognizes that you have devoted significant time and tolerated restrictions on your normal activities during the trial. Your service is a necessary and essential part of the justice system guaranteed by the Constitution of the United States. And I hope you found the experience to be a rewarding one. And I know that, it's not an easy thing to do. So with that, we are going to excuse you. And again, I do wish to express, as sometimes a pattern instruction doesn't really fully express, our appreciation for the service and what you put up with while you serve on a jury. But we are going to excuse you. But again, if you do have any questions, you may remain. If not, you're free to be on your way. And I'll just note for the record that we kept the alternate until after I polled the jury. So then you can also notify, we'd like to give the information to Mr. Tyerman as well. And he can be excused if he wishes. And if he has any questions, then he can remain. Okay, so we're going to excuse the jury. All rise. All right, thank you. You may be seated. All right. Any motions?
Yes, Your Honor. Based on the verdict, the state has two motions it would wish to make. First off, we would move for a judgment of conviction based upon the verdict. Secondly, we would move to revoke bond at this point in time.
All right. Well, does the defense wish to be heard at this time?
No, Judge.
All right. Court will enter judgment on the verdict of guilty as rendered by the jury. And the court will also revoke the bond at this time. And Ms. McCandless will be remanded to the custody of the Dunn County Sheriff. And we will set a sentencing date. So we need a date. I'll order that a pre-sentence investigation be prepared. It is a mandatory sentence. However, there is a parole eligibility date. So we'll...
February 24th.
How about, we'll go off the record for scheduling.
Standard in Dunn County, but in Milwaukee County, I've always asked for a court order that defense counsel be present during the pre-sentence interview. I have never been, no judge has ever declined to order that. I'm aware that the probation department would not let a defense lawyer in, but they will comply with a court order. And that, so I'm asking for that order.
right,
I don't
state, have any
have-
objections?
Oh, I'm sorry. On that issue, no.
Okay, all right, well, I'd ask that you prepare the order for the court's signature.
Usually if you just put it on the order for the pre-sentence, they'll comply,
that
but
too.
in case not, we can get something to you next week. That can go to DOC and it'll have Mr. Nelson's office.
Okay, are we on the record for that, Madam Reporter? Okay, so, but off the record for scheduling, it's kind of ways out there, February 24. Yeah.
So February, Friday, February 7th is fine with the state, Your Honor.
Mr. Nielsen?
AAG Han is not available, but we should be fine.
Ms. Vishny, does that work for you?
Yes.
What time?
I'm sorry, I didn't catch it. Did you want all day or half day?
Oh, Your Honor, it might be better if we have more than a half a day, it sounds like. I think there are quite a few members of the family that may wish to be making statements, so it may take
Starting
more.
at 9 a.m.?
What's that?
Starting at 9 a.m.?
9 a.m. for the rest of the day, maybe, just to be sure.
All right, well, back on the record, sentencing this matter will be set for Friday, February 7, 2020, beginning at 9 a.m., and we'll reserve the rest of the day for this matter. All right, anything further, counsel?
Nothing from the state, Your Honor, thank you.
All right.
I just have a question. How do you want that ordered that defense counsel may be present for PSI interview?
Shall be present.
Yeah, put in there, shall be present.
Okay, thank you.
All right, then, with that, we'll be adjourned. Thank you. Thank you. Ms. McCandless, is there anything you'd like to say?
Hi. I would like to address Your Honor and the courts and Alex's family, but most of all, Alex's parents. I want to say how sorry I am that they have lost their son. But sorry doesn't cut it in my mind. That word is not enough and never will be enough for this loss. And I recognize that. I don't think I could ever find words that will be enough to express this, especially to them. The pain they feel is unimaginable. I want to express how sorry I am for this loss, because it is such a great loss. I recognize and completely acknowledge this pain, and I'm so sorry. I loved Alex very much, and I also feel a great loss. And I'm so sorry. And thank you for letting me say this. Thank you.
All right.
Thank
Anybody,
you, Aaron.
anybody need a recess?
We're prepared for the court to proceed if you would like to proceed at this time.
How about the state? Anybody need a recess?
No.
No? Okay.
You're okay.
All right, well, whew. First of all, I think just because of some of the terms that have been thrown around here today, it's important that people understand how this works in Wisconsin. Normally, court at a sentencing would have to consider probation, but probation is not an option, so it cannot be considered in a first-degree intentional homicide case. So the court is, and we do not have the death penalty. We're not a death penalty state, so none of those things are in play. I think during the career of Ms. Vishny and myself and Mr. Dufour, we've seen 3 different eras of sentencing law. We had indeterminate sentencing, and that was back, I can't even remember when TIS 1 or Truth in Sentencing 1 came along, but prior to that, a person sentenced to life imprisonment would have eligibility for parole after about 13.9 years. I think that was in the defense brief, but if I recall it, I think that's correct. And it would be a parole board that would decide whether a person would get parole or not. And I think it was also cited in the defense memoranda that often people would end up serving between 18 and 21 years before, that was sort of the average, I would imagine. And, but there was a period of time where I guess it began in the 1990s or late 1980s, I think, the tough on crime and things spiraled up, and both political parties in this state tried to keep ahead of each other and being tougher on crime and so forth. And part of that was life means life. It started with court being able to determine, a sentencing court, being able to determine a parole eligibility date. Again, if it was parole, that's why I mentioned that this isn't a parole case, because that's a different, we'd be under a different law. And in any event, so that was, I believe, part of Truth in Sentencing 1, which would be the first change from indeterminate to determinate sentencing. And in any event, then it was a court determining when that parole eligibility date would be sometime in the future, or whether someone would not be eligible for parole. And that was a pretty big change, and it was politically driven. This is what we have to understand. This is what the people of this state wanted. And I think there was a general sentiment that, 20 years for intentional homicide wasn't enough. At least that's my read, has been my read through the years. Again, there are some people that would like to see a death penalty for an intentional homicide, and there's states that have that, and the federal government has that. We don't have that. So even with the enactment of the life means life, and then we move into the Truth in Sentencing 2 era, which was right around 2000, as Ms. Vishny mentioned. And then it was changed so that rather than parole, we have extended supervision, and the court can determine generally in a sentence, bifurcated sentence, and this wouldn't be a bifurcated sentence as I understand it. But still, a court could determine when a person would be eligible for petitioning a court for extended supervision, which would be similar to parole in the sense that person would be released on conditions and so forth, and would be subject to supervision, could have extended supervision revoked if they didn't follow the rules, and could be returned to serve a life sentence. And even in the era when they said life didn't mean life, life still could mean life. I mean, there's a person that I had prosecuted that is still in prison. That's from the 1980s. Not in prison, actually, in one of the state institutions, NGI case. So life could mean life. Life can mean life now, and the legislature gave that authority to the courts and to make that decision. But the way the law is, and what this court has to address, is there's three options. Number one, the court can find under Section 973.014, subsection 1G(a), that a person could be eligible for release to extended supervision after serving 20 years. Number two, a date for eligibility for release on extended supervision on a date set by the court sometime in the future. Or three, that a person is not eligible for release to extended supervision. And the way that it would work for a petition for extended supervision is that a person would have to file a petition sometime not more than 90 days, as I understand, before their eligibility date. And then it would be the court, and again, you're absolutely correct, Ms. Vishny, it would not be this person, but it would be this court, whoever is sitting here, that would either hold a hearing or could deny it without a hearing. The district attorney would have an opportunity, if the court directed, have a hearing on this, but the burden would be on the defendant to show that they're not a danger, so on and so forth. And there could be conditions and so on, but I think that is the defendant would have to prove by clear and convincing evidence that they are not a danger to the public. So, what the legislature essentially has said, and Ms. Vishny, I think you're correct, is that the person has to serve at least 20 years, and then if a court were to say you're eligible at that time. And obviously be sometime after that. But also, the legislature said, again, as the state has recommended here, that there not be eligibility at all for extended supervision, and so you would have essentially life without a possibility of any sort of release. So that's what the court has before it. And Ms. McCandless has been convicted after a trial to a jury, first-degree intentional homicide. It is the most serious crime that we have in this state. And again, we talked here at length about being a mandatory life sentence and with those options. So, the court is of the belief, and I think both parties agree, that the court is to consider the agaiin sentencing factors when making a determination as to when someone would be eligible, if eligible, for extended supervision. And I think those factors, as I see them, are three overall factors: seriousness or gravity of the offense; number two, character of the person being sentenced or their rehabilitative needs; and three, protection of the public. And through other factors, aggravating, mitigating factors in there. But in any event, those are the three overall considerations. So, as I've already touched on, the maximum penalty being life in prison without the possibility of extended supervision. So it was a very, very serious offense. It doesn't get any more serious. And in this particular case, I think it's also appropriate, as in others, not only to look at what the maximum penalties are, but to look at the conduct of a person. Now, I can't address what a different judge in a different county did under different circumstances, and those are certainly not precedents for the court. But in any event, so I focus on this particular case. And this was a brutal homicide. There's no question about it. And it would have been, and it's just awful for the family to have to see these pictures. But what happened to Alexander Woodworth was a terrible crime. And he was had to have suffered a great deal of pain and suffering before he died. Nobody really knows how long he would have lived after he was stabbed the first time. And frankly, nobody really knows what happened or what was discussed or what sparked this. But as far as the crime is concerned, and I'll come back to that in a moment as it relates to the character of Ms. McCandless as this court sees it. And so this is, in addition to the brutal nature, and who knows, again, if he was already dead when she left the scene where his body was, or whether he was still alive and laying there. But fact of the matter is, and I believe the jury's verdict, and you've addressed this yourself, Ms. Fishney, the jury's verdict tells us that they did not believe Ms. McCandless. They did not believe it was self-defense. There's no doubt that she killed Alexander Woodworth. There's no doubt in this court's mind that she intended to kill him. And the verdict is it was not privilege. It was not self-defense, imperfect or perfect. So, and that brings me to Ms. McCandless's conduct. And I'm sure that she was not the person when this occurred that her family knows and loves. I mean, there's a lot of good things about her in her life, but she was not cooperative. She was not truthful. And I guess maybe take that back a little bit. She was cooperative to some extent, but she was not truthful. She lied when the initial emergency responders were there. She lied at the hospital. She lied to Detective Prock on a couple of occasions.
Judge,
yes.
Respectfully, and I hate to interrupt the court, but I am aware of recent cases, and one's before the Supreme Court that requires defense counsel potentially to interrupt the court to preserve the record.
Sure, go ahead.
That's why I'm doing it. And the court is addressing at this point her post-offense conduct. And I did neglect to mention, there's no question that Ms. McCandless lied to Detective Brock and was not truthful with him. And I don't know if the court was going to discuss other factors, but I had meant to call the court's attention to the fact that Ms. McCandless did have a history of post-traumatic stress disorder, including after a rather minor vehicle accident, going through a dissociative state where McCandless did not recall McCandless's name and referred to herself as Monica Carlin and asked where the horse was, even though it was a single vehicle accident. And I did neglect to mention that. So the immediate aftermath, and the court didn't allow the jury to hear about that. I'm not hazarding any guesses. That'll be for appellate lawyers, but I should have mentioned that during my sentencing since you're discussing lack of truthfulness.
All right.
Thank you, and I apologize for the interruption.
Again, I certainly don't fault defense counsel for doing their job. And, I don't know that I'm going to be able to touch on every point that should be addressed here today. We'd be here all day long, and I know that this is getting a little bit long. And but in any event, this court heard the evidence, and there's, frankly, Ms. McCandless was not truthful, and that's what the jury found. I think that's a fact, and we'll never really know for sure what happened. We will never know for sure. And part of the fascination about this case, it's obviously gotten a lot of attention, and there's a lot of interest in this case because I think a lot of people want to know. They want to know what happened. They want to know why. And but we'll never really know for sure what happened. Even if Ms. McCandless told yet another story, which I think would be hard to believe it. I don't think we'll ever know, and the family will never really know the truth about what happened to Alex and how it happened and why it happened and so on. But in any event, I'm going to continue on talking about the seriousness of the offense. So it's serious by maximum penalty, the most serious offense. And in this particular case, it was, again, to parse or to sort out the difference between intentional homicides is very difficult. It's a little like trying to see a shadow in the dark. It's just difficult to do. First degree intentional homicide, they're all bad and all serious crimes. There's no question about that. So we move on to the second, the character of the person being sentenced and rehabilitative needs. And I can tell you, I don't think rehabilitative needs of Ms. McCandless is the driver in this particular case. What I see in this particular case, and I think this addresses two areas. One, talking about this crime, even Ms. Nodolf on her argument, she's saying, well, this just seems so irrational. And I think people struggle to understand what reason there would be for Ms. McCandless to kill Alexander Woodworth. But there's no question that, and I'm just like to note that I have Exhibit 365 and 366, and that was Silence Broken as redacted, as well as the journal number 2. And I think those two documents, those writings by Ms. McCandless, frankly, I think shed a lot of light. She was in a very dark place. She had an awful lot of, first of all, she was 20 and a half years old when this happened. 6 months before that, she had gone through, again, this procedure, which undoubtedly left some turmoil with her, and these relationships, the choices that she made. Frankly, she made a lot of very poor choices. We're free to make choices, and when you're an adult, even though you're not fully developed, and I totally acknowledge the brain science. They train judges on this stuff. In fact, our last judicial conference was almost entirely devoted to the mind sciences, and we heard plenty of that in this case. But as pointed out and I just want to address the issue about the dissociative state. As I understand it, the jury did hear about that through Dr. Benson. And that was, he talked about her history of PTSD. And that's my recollection, is that's why, that's part of the reason the court didn't allow it. But the record was made at the time as to the reasons, and that, again, I have no doubt that there will be an appeal in this case, and there are so many issues the defense can raise, and they will be addressed at that time. However, from what this court could tell, Ms. McCandless had all sorts of things going on, these relationships that she was involved in, her own internal turmoil about what her identity was, her sexual identity, who she was as a person, what she wanted in life. And in this, on page 405, this is document 521, silence is broken. And this was a line that is sort of stuck in my head. I feel like my mind is on fire. And this was written, I'm not sure how long before this homicide. As I understand it, was last, I guess, closed or opened, reviewed just a few days prior to this homicide. Journal number 2, Exhibit 366. She talks about the first line. My mind is deeply haunted by the actions I've done. So she talks about waves of guilt and so on and so forth, pain, regret, disgust, and the word confused comes up in a number of different places. She had an awful lot going on in her mind, and she obviously was angry with Alexander Woodworth. The evidence that came from the communications between Ms. McCandless and Jason Mengel, which comes from document number 551, and that's Exhibit 465. And would have been about 10 days, roughly 10 days before this homicide. And she's talking to Jason Mengel about wanting to go and confront Alex, tell him, and now this is from one of the communications, I just want to give it back and stay out of my life and tell him how much I regret meeting him. And there were a couple of times during those communications where she talks about, one, I'm afraid I might punch him, though, if he gives me a look. Another line, to be honest, I might punch him in the face if he does a sarcastic, "your dumb" voice. And these are communications Ms. McCandless had with Mr. Mengel. So the night before this all happens, Mr. Mengel sends a picture from the wall at Racy's with the words, F me and her phone number. And in the court's opinion, that seems to be sort of the straw that, or the last spark that set off these tumultuous feelings that she had. And next day, Alexander Woodworth ends up dead. And so when she's talking to Detective Prock, they ask her he asks her, why did you go to talk to Alex? And she says, I wanted to talk about my feelings, so my mind is on fire, or feel like my mind is on fire. They didn't elaborate on what those feelings were, but obviously she had anger and some pent-up rage and a whole lot of other things that were going on. And she also wanted to talk to him about what was on the restroom wall at Racy's. So, and what he knew about that and so on. Now, frankly, I agree with the defense that the court has to sentence based on the facts as they have occurred. And I think the analysis, as far as what the evidence is the jury found that when she killed Alex, she had the intent to kill him. The jury didn't find when that intent was formed. And frankly, in this court's mind, and I've had a lot of time to think about this case, and believe me, I've thought about it a lot. There was perhaps, again, suicidal ideations, perhaps homicidal ideations, but the evidence proves that when she killed Alex Woodworth, she had intent to kill him. And in large part, had what was going on in her life and her being immature, again, being only 20 and a half years of age, certainly, I don't think anyone could disagree that in the science that her prefrontal cortex was not fully developed, that she didn't have very good breaks. And Jason Mango suggested she not go do that. He didn't want to go along. She had asked Jason in those communications to go along because she wants to tell Alex off. And then that's before the business about the learning about her number being on Racy's in the bathroom wall. So, frankly, from this court's perspective, what we know is that she boiled over at some point and killed Alex Woodworth. And it was not in self-defense. And she lied about what happened, which is, frankly, not that uncommon. She is a person that does have her personality traits. There's a lot of good things people have said about her, people that have known her, and there's probably a lot of good things that she could do, in a prison setting. But the fact still remains that, we talk about 5 to 10 years of rehabilitation. Maybe that's in some cases. Most people that go to prison, they aren't even there for more than a couple of years, frankly. But this is an intentional homicide case. So that brings me to the third factor the court has to consider, and that is, of course, protecting the public. And we can't predict the future, but the best predictor about the future is what people have done in the past. And so we have, again, in this particular case, someone who killed another person, took another life. And I think that's, the public expects to be protected. We don't know. I can't tell right now whether she's going to be dangerous 20 years from now, or 25, or 40, or more. So, in any event, court has to consider those factors when imposing a sentence in this case. Now, what the court has considered for purposes of sentencing would be, again, some exhibits from their record. I've received the pre-sentence investigation report, which recommends life imprisonment with eligibility for extended supervision at 50 years. And I've considered the state's sentencing memorandum and their arguments and the people that have spoken here today, the victim input side of things, and the state's position is life imprisonment, never an opportunity for extended supervision. And then the defense argument, of course, life imprisonment, and your sentencing memoranda, some letters that were contained in that, as well as some pictures of Ezra with interacting with family and so on and so forth, and is asking for extended supervision at the earliest possible time. And
Judge, I hate to interrupt, but we're asking for the opportunity to petition a court.
Yes, exactly. And that's, I think, for people to understand that the court would not be setting a release date here today, just a date when a person would be eligible for extended supervision. So, what the court has not seen in this particular case, I'm just going to go through some factors in order here. Her past record, she didn't have any prior criminal convictions. And frankly, there was no evidence of prior violent behavior that this court heard. She was only 20 and a half years old, not far out of high school. And again, I've already mentioned the nature of the crime itself here. And but what the court saw during the trial was she did not, there does not appear to be any remorse, does not appear to be any genuine contrition. And I just want to make sure and make it clear that not holding it against Ms. McCandless that she did not say anything to the PSI writer. Again, she has a right to appeal. And she has a right to remain silent. That cannot be held against her at sentencing. But what I'm talking about is what she testified to and what she said, what was testified that she had said to investigators. And but there, and I don't know, maybe a little bit today, I don't really feel like it was really sincere. I'm sure she feels bad, but again, I don't believe we have the truth. And I think one thing a family would want to have more than anything else is to know what the truth was. And I don't want to, I guess, forget to mention, that this is, in the court's opinion, has to do with the family, the victim, and by definition, close family members are victims of this offense, and their input is important. And so court allowed evidence by the defense. I believe that's based on the law, at least this court's interpretation of the law, and that's characterized by some as an assassination of Alex's character. Frankly, people are entitled to put on a defense. But again, those facts and that testimony was rejected by the jury. There is no evidence that Alex Woodworth had done anything wrong at all. And from all accounts, even from what Ms. McCandless says, aside from what she testified to, he was a kind person, gentle person, witty, compassionate, just so many adjectives that I've heard about what a good person that he was, and I don't doubt that. So this is a great loss, not only for his family, for his friends, his community, but it's very tragic. And I agree with Ms. Gunnelson when she says no one wins in this case. Nobody wins in this case. This is just a horrible, 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 horrible case. And that is the way it is. So, after considering all of these factors, I just want to say that I've thought about this case pretty consistently, for a long time, and I understood, what the court's choices were, because I looked at the statute quite a while ago before I received the pre-sentence investigation report, and in this court's opinion, I had thought this is a case where there should be some date for release on extended supervision. But I cannot agree with the defense, because I think 20 years would certainly unduly depreciate the seriousness of this offense. From my view, from the community that I serve, and again, this isn't my personal spot here. This is on behalf of the community, and in this court's opinion, that would unduly depreciate the seriousness of a first-degree intentional homicide for someone to be out that soon, rehabilitated or not. The seriousness of first-degree intentional homicide, at least by community standards, in this court's opinion, requires more than that. However, I do not believe, and there are a couple of cases that I was the prosecutor on, where people got life without realistic possibility of parole, one without possibility of parole. I certainly haven't been involved in as many homicide cases as you have, Ms. Vishney, and I guess I'm glad for that, because they are not, and there's nothing pleasant about it at all. But in any event, the court believes that the date that the pre-sentence investigator, writer of the report, Mr. Erickson, frankly, when I got the pre-sentence investigation report, that was a number that's right around what this court was thinking. It's gone up, it's gone down, it's gone back and forth a little bit. Mr. Hall's comment that, maybe 60 years, 1 year for every day they had to wait. And again, this whole situation is difficult on everybody. You know, having the publicity in a case like this is difficult on the family. You know, and having to wait to have a loved one's body because you're concerned about it being preserved for evidence, and that the defense might at some time, you know, object that potentially exculpatory evidence may have been lost because the body was returned to the family. And I think in every case we learn a little bit. It's unfortunate. Frankly, I don't recall that, and it's difficult. It's difficult for the family to have to be, you know, on TV and all that. It sort of changes the way people behave, I think, when you get this much coverage, and that, you know, the coverage is here to capture what happens, but yet what happens sometimes changes a little bit because of the coverage. And but I have never been involved in a homicide case that did not have TV cameras in the courtroom. In Wisconsin, that's the way it is. So the court believes, and here's what the court is going to do for the reasons that I've stated. I am going to sentence Ms. McCandless to life in prison in the Wisconsin prison system, and I'm going to set the date that she would be eligible for petitioning the court for extended supervision at 50 years. It's a long time, but the way I reason this, that Ms. McCandless, if she does what she's supposed to do, follows the rules, that she at least has some light at the end of a very long tunnel. It's a long time. I won't be around. I'm pretty sure I'm going to be gone, like dead at that point. But I think I've thought about that for a number of different reasons. I think that way that Alex's parents, you know, I don't know exactly how old they are, how long they have yet to live, but that spares them to have to see the day Ms. McCandless may petition to be released and perhaps have to go through some hearings. It's a long time down the road and does not unduly depreciate the seriousness of this offense in the court's opinion. And if this was a death penalty state, there would be no opportunity ever for that. But this is an intentional homicide, and it is that serious in this court's opinion. I think people expect, if maybe not an entire natural life, but at least if 50 years is a point where I think most people can agree that would not unduly depreciate the seriousness of the offense, and she would most likely not be a risk to the public after a very lengthy period such as that.
Judge, as far as the sentencing credit goes, the state said 683 days. That would date from the date of the first appearance or when bail was set. But if you date it from the date that she was taken into custody by law enforcement, it would be 692 days, or March 18th of 2018. And
I think the date she was taken into custody was March 27, 2018.
No, she was taken into custody at Mr. Sippel's residence. She was never free to leave after being at Mr. Sippel's residence.
Well, she was not in police custody. She was not arrested on this offense, as I understand it, until March 27th. That's my finding. So, and I added it up. I come up with 683 days credit, including...
Okay, well, my record's preserved.
Including today, yeah, certainly. So, I am required, Ms. McCandless, to advise you of some information. You will get a copy of this written explanation of determinate life sentence. Again, your length of your sentence is life imprisonment. And you would be eligible to petition for release to extended supervision after serving 50 years, 0 months. And I think you can read for yourself about extended confinement or bad time. I don't normally read that at a sentencing, but I think the statute does require that I advise you of this information. And that is from section 302.114 of the Wisconsin statutes. And actually, in any event, the court is supposed to read that information. It's contained in this form, which is CR 235. And again, a copy will be put in your, provided to the jail for your personal belongings. But you may file a petition for release to extended supervision with this court. The petition cannot be filed earlier than 90 days before your extended supervision eligibility date. If your petition is filed any time earlier than the 90 days, the court will deny the petition without a hearing. You must serve a copy of your petition on the district attorney's office, and the district attorney will file a written response to your petition within 45 days after receiving the petition. The court will review your petition and any response filed by the district attorney and may grant or deny your petition without a hearing. If the court holds a hearing, the hearing will be before the court without a jury. The district attorney who prosecuted you will represent the state at this hearing. Now, again, I don't know who the district attorney will be 50 years from now, but it would be the Dunn County District Attorney. That's the point. Before this court can grant or deny your petition, any victim or any other person may make or submit a statement relevant to your release to extended supervision. This court cannot grant your petition unless you prove by clear and convincing evidence that you are not a danger to the public. If your petition is granted, this court may impose conditions on the term of extended supervision. If this court denies your petition, it will set a date on which you may file another petition. If it is filed prior to the date set by the court, it may be denied without a hearing. You may appeal an order denying your petition for release to extended supervision. Now, a number of other things may seem like formalities. The court does have to impose court costs in this matter. I believe it would be $268 plus a $250 DNA surcharge. That's a total of $518. I'm also going to order restitution.
Your Honor, I believe it's 6.
I have it here. Okay. So the restitution would be, first of all, to Marvin and Joan Woodworth for cost of travel and cost of funeral. Cost of travel, $1,602.30. Cost of funeral, $3,940. And then also for Sarah Woodworth for missed work for a funeral. And that's calculated out at $312. And travel from Nebraska, $458.89 for a total of $6,313.19. And there's a victim witness surcharge of 10% added onto that for a total of $6,944.51. Now, I understand that's not contested, and but the court believes that those are reasonable expenses for restitution for the untimely death of Alexander Woodworth. And if things went as they should, his parents or grandparents or anybody shouldn't have to pay for his funeral. And hopefully, his funeral should have been well after his parents were gone. Now, so the court will order that. You may request a restitution hearing if you wish. I will order that up to the maximum amount allowed by law, that there may be deductions from any prison wages to pay towards restitution and court costs. And again, counsel indicated that was 50%. I thought it was 25%, but
It was 25%.
just raised it to 50.
It is 50.
I believe
50?
it's now 50.
Okay, so I'll order up to 50% of any, I guess it's any amounts in her accounts in prison. It's not just prison wages, but it's taken from other monies she may have, prison funds. Now, other conditions. Now, I will order it, and if it's not allowed, it's not allowed, but I will order that she have no contact with Mr. Woodward's family.
Judge, I'm going to ask for modification of that. I'd ask that she not be allowed to initiate any contact with Mr. Woodward's family. I'm aware that there's a restorative justice program that goes on in the state of Wisconsin, and sometimes in the future, victims' families want to go through a restorative justice hearing. So I would not want that to be precluded by today's sentencing. So I would ask that it be changed, that she not initiate contact, because as we know, we don't know what will happen in the future. But this is something that does from time to time go on. And people who've gone through it find it incredibly healing. I don't want to preclude that possibility.
I don't, if the victims wish to have contact, so I'll just say no contact with any member of Alex Woodward's family unless that family member initiates contact and requests contact or participation in any sort of restorative justice. But again, this isn't like conditions of extended supervision. This would be, and I just a little unsure as to how that works with a prison sentence, because prison will have their rules as well. All right, this is a felony conviction. Obviously, Ms. McCandless, you may not possess a firearm ever. It's a permanent prohibition. Serious penalties under both state and federal law. You may not vote in any election until you've completed your sentence, which I think that would be, even if you ever are granted extended supervision, you would still a life sentence, so you would never be able to vote again in any election. Also, did she have a DNA sample taken at the time of arrest? I'm sure there was DNA samples taken, but by search warrant. But we'll order that she submit a DNA sample that can be done down at the jail. Also, I believe, given it is a violent felony, she is prohibited from possessing body armor as well. That's a warning the court has to give. All right, Ms. McCandless, you have 20 days from today to file a notice of intent to seek post-conviction relief. Again, counsel, I just want to say you had a vigorous defense. Your attorneys, I think, did an outstanding job of raising issues. I think both sides in this case did an outstanding job. I can't imagine there would be any other issues that would have to be resolved before a direct appeal, but there's always that possibility. I think, again, this was, counsel were thorough, and I think did zealously represented Ms. McCandless. All right, is there anything further, Madam Clerk, anything I've missed? All right, from the state,
Your Honor,
anything I've
probably,
missed?
it's just a formality, but could you just advise her of her immigration right and could result in deportation?
Ms. McCandless was born in the United States.
Well, if you read that statute, this isn't a plea, so I don't think that's necessary. Anything else? Okay, that's all. We're adjourned.